Right, let's get on with our next case, Romesh Thapar versus the state of Madras. This is one of those cases which was a significant landmark judgment but has been forgotten over the years. Its impact is not really remembered, which makes it really an ideal case for our discussion in the on the history of the Supreme Court of India. The facts of the case are slightly complicated, much more than A.K. Gopalan, but significantly crucial to look at the entire background. The story begins in February 1950 when some communist prisoners detained in the Salem Central Prison uh, went on strike. Their grievance was that they were being treated as common criminals rather than as political detainees. They were political detainees. They were being detained on account of being communists, and they were being treated as prisoners who are undergoing punishment for some significant crime. One example that they complained about was that they were being made to wear black caps. Black caps were limited to those who had committed heinous crimes such as murder and rape, etc. And these prisoners refused to take such treatment lying down. In short, in a nutshell, they were making the same protest that Bhagat Singh and his colleagues had made when they had been imprisoned by the British, that they were political prisoners, not common criminals, and they should be treated accordingly. The authorities in the Salem Central Jail did not respond to the strike favorably. They tried to enforce the will of the authorities, which led to a fracas, and in the ensuing fracas, uh, the authorities opened fire on some of these detainees. There were over 200 of them. Over 100 of them were enclosed in a room locked from outside. These are what the news reports from those days suggest. And then they were fired upon from the windows of that room. 22 detainees were killed, over 100 were injured, many of them seriously, many of them were maimed for life. And this retaliatory firing by the jail authorities was found to be appropriate by an inquiry commission after the event. Now, it is simply unbelievable for us to imagine these kind of things happening, but communists had a kind of a reputation at that time that they were trying to overthrow the state, and they were trying to do that violently. They were trying to bring about a communist revolution in the country just while we had achieved independence and a republican status. So perhaps people reacted to these events slightly differently than what we would react today. Nonetheless, there was one Bombay based English weekly named Crossroads which criticized these actions of the Salem Central Jail authorities. And this was done in a series of articles. This is a weekly magazine, it was. And even after the cooling down period that you tend to see as the days pass, the criticism continued. And when the criticism reached proportions which the government believed was harmful to it, the Madras government banned the circulation, banned the entry of copies of Crossroads into the provincial borders of the state of Madras. This is, as I said, it was a Bombay based daily. And when they tried to circulate it in the state of Madras, where the event had actually taken place, the state of Madras banned the entry of copies of the Crossroads Weekly and banned the circulation of these Crossroads magazine copies. The order was passed on the 1st of March 1950 under Section 91A of the Madras Maintenance of Public Order Act 1949. This was a pre-constitution act, as you can see. It was an act made under the Government of India Act 1935, which saw a similar demarcation between union subjects and state subjects, and this was under a state subject at that time, which included public order, which of course is the case in the post-constitutional structure of our country as well. The act itself is not available anywhere anymore. Unfortunately for us, the judges in the judgment have not exactly quoted verbatim the section under discussion, but we have ways of extracting whatever we can, and we will discuss the section a little further down the line. Now, the editor of Crossroads, who also happened to be the printer and the publisher of this magazine, so it was largely a one-man show, and that man was Romesh Thapar. Romesh Thapar belonged to one of the establishment families. His uncle was an army officer, a senior army officer, a lieutenant general, and his father was also a well-known advocate. Romesh Thapar himself went to England to study, and apparently that is where he was influenced by socialist and communist ideas. And when he returned to India after his education, he founded this weekly, Crossroads, in Bombay, largely with his own capital. Therefore, when he was faced with this issue, where his magazine was stopped from being sold in a large part of India, state of Madras at that time was quite significantly huge. It included today's Tamil Nadu and parts of today's Kerala and some parts of Andhra Pradesh as well. So all of that territory was unavailable for circulation of his magazine, simply because the criticism meted out in it was a bit too much for the government to swallow. So Romesh Thapar actually made an appeal for funds for fighting this order in the Supreme Court. His magazine kept on publishing, of course, in Bombay, and apparently appeals were made for funds from there. So those are the basic facts, the very basic facts of this case. Article 32 is the provision of the Constitution under which Romesh Thapar approached the Supreme Court, and the topic under discussion was public order. So section 91A of the Madras Maintenance of Public Order Act 1949, as I said, I was not able to find the actual enactment or the actual words of the provision, but it has been described in different places as a provision which authorized the provincial government to prohibit or regulate the entry into or the circulation, sale or distribution in the province of Madras of any document or set of documents for the purpose of, what was the prohibition for? It was for the purpose of securing the public safety or the maintenance of public order. Now, this public order term was the crux around which the entire case uh, hinged. The idea was that, as far as the state of Madras was concerned, was that public order implied security of the state, while the petitioner's argument was that public order was not a reasonable restriction uh, allowed in Article 19. Article 19, of course, 19(1)(a) states that all citizens shall have the right to freedom of speech and expression. Article 19(2) gives the reasonable restrictions on that particular right to freedom of speech and expression. 19(2) says that freedom of speech and expression is restricted by the laws of the laws of defamation, that is slander and libel, as well as the law of contempt of court, right? So that is an obvious restriction on the freedom of speech and expression. And at the same time, the right to freedom of speech and expression is also restricted if that speech or expression undermines the security of the state or tends to overthrow the state. All right, those were the only restrictions in the original Article 19 Clause 2. It has since been amended, and this judgment has had a say, has been instrumental in amending Article 19 Clause 2. Let me just take a quick pause. So, just a quick pause to ensure everybody gets a chance to read what Article 19, Clause 2 originally restricted. It only restricted speech that was, excuse me, that was in relation to defamation or contempt of court, or if that speech undermined the security of the state or tended to overthrow the state. But the phrase public order did not exist in the original words of Article 19, Clause 2. And we are still in the early phases of our constitution and of our constitutional jurisprudence, and indeed our fundamental rights jurisprudence, which meant that just like in A.K. Gopalan, the court was likely to do a strict interpretation of the words of any statute as well as any constitutional provision, and instead not go for a wider reading, except that this time it was the government which was seeking a wider reading. Quick look as usual at the names of the counsel for both parties. Romesh Thapar was represented by the well-known advocate C.R. Pattabhiraman. His father was an even more well-known advocate, while Mr. Pattabhiraman, of course, himself had been a freedom fighter. He had been involved in the protests against the Simon Commission in 1929, and he was also later on after this case, much down the road, he became a minister in the central government as well. He was a freedom fighter, he was a member of the Congress party, and on this occasion he was uh, advocating a citizen who was fighting against the state of Madras, which was governed by a Congress government. The state of Madras was represented once again by Mr. K. Raja Iyer, the Advocate General, who had assisted Attorney General Setilwad in the Gopalan case, which ran almost concurrently, which was decided just a week before. So, Mr. Raja Iyer had already tasted success in a constitutional case. This time he would be on the other side. Spoiler alert. The first argument made was a preliminary objection raised by the state of Madras, and this is a very interesting one. The objection was that the petitioner should have approached the High Court under Article 226 and not directly the Supreme Court under Article 32. This is what the state of Madras contended, that Romesh Thapar should have approached the Madras High Court for whatever relief he was seeking and not come to the Supreme Court. Now, this is the kind of argument that flummoxes the layperson. What was the purpose of this argument? What would be achieved by this argument? Some might think that did the state of Madras believe that they were likely to receive a more favorable hearing from the Madras High Court? Is that what the purpose was behind this argument? Probably not. The likelier reason for this argument, and one can only speculate from this distance of time, but the likelier reason for this argument was strictly dilatory, and this was a valid delay. The hope perhaps was that if the Supreme Court agreed with this argument and asked the petitioner to instead now go and approach the Madras High Court and make the case before that judicial body, there would be some time lost between these days, between the day of that particular order by the Supreme Court and the actual hearing made by the High Court, and then the case proceeding from there. And this delay would be perhaps sufficient in helping cooling down the matters in the state of Madras. Obviously, there must have been some inflammation of some incitement or some arousal of some inflammation of thoughts in the people over there that would have calmed down by the time the case went to the High Court and then was heard there and then was decided there, and perhaps by that time there would be no need to stop the circulation of crossroads in the state of Madras. Perhaps that is one of the reasons. That is the positive reason that we can think of. The negative reason, of course, would be that the petitioner had already spent significant amounts of money in approaching the Supreme Court, and if that had all come to naught, would have to raise money again to approach the High Court, by which time perhaps things would have changed significantly. The response by Romesh Thapar's advocate was quite straightforward, that the petitioner was merely exercising his fundamental right under Article 32, which said that we can directly approach the Supreme Court in case our fundamental right is infringed. And this was the argument that the Supreme Court agreed with, that there is no reason why Romesh Thapar should be prevented from approaching the Supreme Court for this particular relief. This is an interesting argument here itself. This case, just by this preliminary objection and its redressal by the court, has already made it a landmark judgment, even before the issues at hand have been heard. Later on down the years, the Supreme Court did go on to advise petitioners to first approach their local High Court. The workload of the Supreme Court kept on increasing over the years, and also the fact that if you approach the High Court and do not get the relief you were praying for, you would still have an appeal with the Supreme Court. And therefore, later on, much later, the Supreme Court did advise basically what the state of Madras was suggesting over here, but not over here. Over here, the Supreme Court perhaps saw through the argument and anyway continued its streak of strictly following the Constitution, the words that were written in the constitutional provisions. One of them was Article 32, which said that we can directly approach the Supreme Court if we believe our fundamental rights have been breached, have been infringed upon. And that itself, approaching the Supreme Court itself, is also a fundamental right. The Supreme Court is not going to stop you from exercising your fundamental right. Once that argument was thrown out, the petitioner was allowed to make his argument, and his argument was that Article 19(1)(a), which talks about freedom of speech and expression, also includes the freedom to propagate the ideas, the liberty to circulate these ideas. This freedom to propagate, this liberty of circulation, is essential to the freedom of speech and expression. So, over here, the crucial argument that Romesh Thapar needed to make was that when the Constitution provides for the right to freedom of speech and expression, this includes the right to spread that speech, to propagate the ideas presented in any speech. Whatever you are speaking, you are allowed to distribute that as well. Otherwise, it is not a freedom at all, or not a freedom to speak at all. Because if you are being told that yes, you can speak whatever you want to, provided nobody listens to it, is obviously making that provision infructuous. This argument relied on a couple of American Supreme Court cases, Ex parte Jackson, a very old case in the 18th century, and Lovell versus the city of Griffin. The city of Griffin, not dissimilar to the state of Madras, had prevented or attempted to prevent the propagation of certain documents into the premises of the city, and the Supreme Court had found, the US Supreme Court had found in favor of the distributor. So another important aspect then of this judgment, that foreign cases were once again relied on, although merely for their persuasive value. Nonetheless, they were referred to by the Supreme Court of India, just as they had been in the Gopalan judgment. But in this case, the Supreme Court favored the arguments made by Romesh Thapar. The state of Madras, on the other hand, tried to increase the scope of that section 9(1)(a) of the Madras Public Order Act. Section 91A, as we saw, talks about public safety and public order. It does not talk about security of the province. It does not talk about security of the state or overthrow of the state, as is required by Article 19 Clause 2, in case you want the law to be valid as far as restricting freedom of speech and expression are concerned. If you want to write a law which restricts the right to freedom of speech and expression, then that law should be aimed at securing the security of the state, of ensuring that there is no speech or incitement to the overthrow of the state. Section 9 clause 1a, on the other hand, talks only about public safety and public order. The state of Madras was hoping to convince the Supreme Court that public safety implies safety and security of the entire province, of the public in the entire province, consequently by implication the entire province, consequently by implication the security of the state. It was the government which was now asking the Supreme Court to give a wider interpretation to the words of a statute. The court was consistent. In the Gopalan case, it refused to give a wider interpretation to the words in the constitution. Over here, it refused to give a wider interpretation to the words in this particular statute, and that is why section 91A of the Madras Maintenance of Public Order Act 1942 was found to be ultra vires. Vires is capability or power, ultra is beyond the capability, beyond the power of the legislature to pass such a bill, such a provision, to enact such a legislation, because it violated Article 19(1), and that violation did not fall in the restrictions that were provided for in Article 19 Clause 2. Therefore, that section was held void. Therefore, the order made under it to ban the entry and circulation of the Crossroads magazine into the state of Madras, that order was also held to be void ab initio, and therefore the order was quashed. Therefore, Romesh Thapar was able to circulate his ideas. This proved to be a significant victory for the right to freedom of speech and expression. Unfortunately, as is often the case in our constitutional jurisprudential and legislative history of our country, we will find that the story did not end here. This case and the next one that we are going to discuss, which was also decided on the same day, which also dealt with Article 19 Clause 1 and Article 19 Clause 2, 19(1)(a) and 19(2), dealing with speech and expression. That is the Brij Bhushan case, both decided on 26th May 1950. Both of these eventually led to the constitutional restriction of our freedom of speech and expression by the passage of the First Amendment of the Constitution. Interestingly, those of us who are students of comparative constitutional law will recall that the First Amendment of the United States Constitution increases the scope of freedom of speech and expression. The First Amendment of the Indian Constitution restricts the freedom of speech and expression. But until that was passed, Romesh Thapar versus State of Madras remained the law of the land, remained the provision under which the freedom of speech and expression in our country was protected. So that's that on this case. I decided to make a single video for the entire case because there were multiple cases that were going to deal with the same aspect, and all of them will be in this same playlist. So look for them coming up. Thanks for listening. Have a good time. Bye bye.